Good evening, Your Honors, and may it please the Court. My name is Michelle Marion, and along with my co-counsel from whom you just heard, I represent Ms. Dixie Herbster, the appellant in this case. I will be addressing her concern for the ineffective assistance of counsel rendered by her ex-husband, Mr. Herbster. Your Honors, this issue concerns safeguarding a criminal defendant's right to competent representation. As this court explained in Cantu v. State, competence goes to the heart of the Sixth Amendment right to effective assistance of counsel. We ask this court to reverse the 15th Court of Appeals for two reasons, and under two different tests. First, under the test in Cantu v. State outlined by this court, we ask that you find, because Mr. Herbster had already been suspended from the practice of law prior to the trial, that his counsel was ineffective as a matter of law. Second, we ask that you find that his counsel was also ineffective as a substantive matter under the Supreme Court's test in Strickland v. United States.
He wasn't suspended at the time he undertook this representation, though, was he?
Yes, he was, Your Honor. He had actually been suspended. He received the letter 2 days prior to trial, however, he had not opened it yet, so he was not aware that he was suspended.
But he was suspended at the time.
Yes, he was. And he was also, Your Honors, aware that there was a pending proceeding against him by the CDC. And this information he failed to disclose to his client, which kept her.
Was he married to his client?
He had been married and divorced from his client 2 times, Your Honor.
And you're telling us that she didn't know that he was having these issues with the bar?
The record does not say that he specifically told his client that he was under investigation by the CDC.
And the issue that he was under investigation for was his representation in his only other criminal case, which was a DWI manslaughter, right?
That is correct, Your Honor.
So, and she knew about that case. She knew what happened in that case, right?
It is likely that she did.
Why shouldn't we say she walked into this knowing the risks of hiring someone who only tried one other case and had some controversial issues come out of that? Why can't we say she waived?
Because, Your Honor, the Sixth Amendment imposes a duty upon the attorney, not upon the defendant herself. And Mr. Herbster was aware that he was incompetent in the prior proceeding, and he should have disclosed this information to his wife, and he should have to his ex-wife, and he should have declined to take the case. In fact, the CDC found that he had violated 2 rules, both Rule 1.01a and 1.01b, which subsection A, he violated that by taking a case in a federal criminal case when he was incompetent to handle that case. And as mentioned before, competency goes to the heart of the Sixth Amendment. And there is a critical distinction between technical violations, such as failures to pay bar dues or respond to requests for information, which were at issue in Cantu itself and several other cases out of Texarkana Court of Appeals. There's a critical distinction between those sorts of procedural violations and substantive violations reflecting upon competency. And that is what Mr. Herbster was found guilty of, and why his license was suspended for 2 years prior to this trial. Now, this court in Cantu v. State enumerated 7 non-exhaustive, non-exclusive factors to examine in order to determine whether a prior sanction renders counsel ineffective as a matter of law. It is also important to note that this does not, prejudice is not factored into this equation as it is under the Strickland test. We anticipate that the appellees will rely upon the first and the 7th factor, one being the severity of the sanction, since it was a suspension rather than a complete disbarment. However, the CDC did consider disbarring him at the time. And the final factor, which we anticipate the appellees will rely upon, is the nature and extent of his professional experience and accomplishments, which the record indicates that Mr. Herbster has tried 20 civil trials. However, he has only tried 1 criminal trial Mr. Redbeard, who received the maximum punishment and filed a grievance with the state bar for which he was suspended. And there is a critical difference between civil law, or the practice of civil litigation, and criminal litigation. As you can see from his deficient cross-examination and his deficient performance during voir dire, where he actually doesn't even understand the basic principles of criminal law, such as the Miranda doctrine. In fact, he asked Mr. Appleby, a scientist, if he had given the Miranda warnings to his clients, showing that he does not understand that custody is an essential element for the Miranda doctrine. This shows that even though 2 years had elapsed since the Redbeard trial, he had not taken it upon himself to learn criminal law, and therefore he should be found to be ineffective as a matter of law. While no court in the state of Texas has actually found ineffectiveness as a matter of law, the Second Circuit, and California in particular, apply a per se rule for egregious conduct, such as the CDC found during Mr. Redbeard's trial. In fact, in the Seventh Circuit in U.S. v. Merritt applied a per se rule of ineffectiveness as a matter of law when an attorney had passed the Iowa bar, but had 3 times failed to pass the bar in Indiana. And he tried a case in Indiana, and that was determined to be ineffective as a matter of law. Your Honors, the criminal courtroom is Mr. Herbster's Indiana. Just as that attorney was competent to practice in Iowa, Mr. Herbster may be competent to practice in a civil case. And just as that attorney is not competent to practice in Indiana, Mr. Herbster is not competent to practice in a criminal case.
Isn't there an inherent paradox in your whole appeal here that if we sustain your appeal on the confrontation clause, how can we then rule that Mr. Herbster was incompetent, and vice versa? If we decide he's, how can we do that? If you went on the other point, then don't we actually have to find that he's competent?
No, Your Honor. While Mr. Herbster Mr. Herbster failed to subpoena Ms. Lindsay, the blood work analyst, and though it was the state's burden to meet the confrontation clause, it was Mr. Herbster's burden to meet the effective assistance of counsel clause. And under either standard, Ms. Herbster did not receive a fair trial, and we ask this court on either ground to reverse and allow her to have a new trial with a new attorney in which her confrontation clause rights are also met.
Wouldn't it be pretty obvious trial strategy for a criminal defense attorney not to subpoena a prosecution witness?
That is, in fact, Your Honor, what Mr. Herbster claimed was his strategy. He says that he has asked around and found out amongst criminal attorneys in the neighborhood that Ms. Lindsay, her reputation was rock solid. And that was his supposedly reasonable trial strategy in failing to subpoena her after he learned that the state was not going to call her. However, regardless of the fact that he was knowingly allowing his client's confrontation clause rights to be violated, he also should have called Ms. Lindsay and subpoenaed her, because it was her testimonial evidence which was being submitted, as my co-counsel has already explained. And he also knew that she was not coming to court because she was suffering from mental health issues, and that she had had a sexual relationship with her supervisor, the man who did testify.
Doesn't the record say he denied having a sexual relationship? He admitted a romantic relationship?
Yes, Your Honor, I apologize. Yes, he was having a romantic relationship with her. But with both of these factors, the relationship and the mental instability, if she had been subpoenaed, a reasonable trial strategy would have been to undermine her credibility, not the credibility of a supervisor who did not even perform the test.
But your co-counsel just argued that he had no obligation to subpoena the analyst, that was totally on the state's side under the confrontation clause, and that the fact that he didn't subpoena her should have no bearing on our ruling under the confrontation clause. It seems like you're taking inconsistent positions here.
Yes, Your Honor, under the confrontation clause, it was the state's burden to subpoena Ms. Lindsay.
But you're telling us under the effective assistance of counsel doctrine of the same amendment to the Constitution, it was his burden to subpoena.
It was not necessarily his burden, but in this case, a reasonable trial strategy would have involved subpoenaing this witness. And under the Strickland standard,
Is there no reasonable trial strategy for not subpoenaing? Isn't that the standard, that there can be no reasonable reason for not taking the action?
yes, Your Honor, and even if you do find that failing to subpoena Ms. Lindsay was a reasonable trial strategy, there are two other incidents which appellants point to that do demonstrate a deficient performance in the court below, namely the failure to investigate the Kane test and the state's expert, Mr. Appleby's, assertions about this test, as well as his deficient cross-examination of Mr. Appleby himself. Now, the Kane test purports to examine an supposedly objective reaction to alcoholic beverages in order to determine whether an individual is likely to drink and drive again in the future. However, Mr. Herbster failed to find two articles that were published 5 weeks prior to trial rejecting the Kane test and claiming that it was ineffective and unreliable because it actually has only a 65% effectiveness rate for females. Mr. Herbster relied only on the word of Mr. Appleby. He did not even read Mr. Kane, the man who invented the test himself. His own study says that it was 65%. Mr. Appleby, however, lied.
If the trial judge, though, decided that 85% was good enough, what reason do we have to believe that the trial judge would have then decided that 65% was not good enough? They're both, above 50%, more likely than not.
While it is more likely than not, Your Honor, it was presented to the jury as an objective fact that with at least 85% assurance rate, Ms. Herbster was likely to drink and drive again. However, if the jury had heard the 65% error rate instead, it is reasonable that they would not have given it as much credibility. That goes to the prejudice prong of the Strickland test. Furthermore, there was also an unpublished opinion by the 15th Court of Appeals that came out 2 weeks prior to trial, which said that the admission of the Kane test in a criminal case was reversible error. If Mr. Herbster
Is
had...
there a rule of appellate procedure that tells us when non-published opinions are binding precedent and when they're not?
In the state of Texas, Your Honor, after 2008, I believe, an unpublished opinion is, I believe, still binding. However, it was the court below in this case that gave that opinion. Therefore, if Mr. Herbster had presented it to the trial court, it is likely that Mr. Appleby would not have been certified as an expert. And that, again, goes to the prejudice prong. And for all of these reasons, we ask that this court reverse the lower court and find that Ms. Herbster's Sixth Amendment rights to confront the witnesses against her. I see that I'm out of time. Thank you.